morning, everyone, and thank you for joining us today. We are live again with another webinar for you, and today we're talking about the Building Safety Act. My name is Shumaila Yusuf, and I will be the host for today's webinar. Before I let the panelists introduce themselves, just a little bit of housekeeping. Firstly, with regards to rewatching the webinar, this session is being recorded and will be made available shortly after the webinar's ended. So please feel free to rewatch it or share it with your colleague, and please keep an eye out for the webinar. Our chat feature is enabled, and we welcome you to pop any questions that you might have through the chat that is now enabled, and we will try to answer as many questions as we can during the session. Joining me today on our webinar are two guests, Richard Waterhouse and Jon Vanstone. I will let them introduce themselves, as I believe that they will do a better job than I will. So, Jon, would you start, please?
Yep, certainly. Hello, everyone. My name is Jon Vanstone. I'm currently the chair of the Interim Industry Competence Committee under the Building Safety Regulator. I'm also a member of the Building Regulations Advisory Committee while it's still in existence, and I'm a director of the National Home Improvement Council.
Hello, everybody. I'm Richard Waterhouse. I'm a non-exec director of BBA, and in previous roles, I was with NBS for 26 years, and 18 of those I spent as chief exec. And I've also been involved in the world of standards, chairing the British Standards BIM Committee for 6 years as well.
Thank you both, Jon and Richard. So the first question, Jon, to start us off, could you give us a little bit of history of the Building Safety Act and how we finally got here?
Okay, sure. It's a bit lengthy, but if you go back to 14th of June 2017 and the Grenfell Tower tragedy, the fire that killed 72 residents in what was deemed the worst residential fire since World War II. July 2017, there was an independent review of building regulations and fire safety. This was introduced by government and led by Dame Judith Hackitt. Its purpose was to make recommendations that would ensure a sufficiently robust regulatory system for the future. Then in December 2017, there was publication of the interim report, setting out 6 broad areas for change. May 2018, the review's final report was created with 53 recommendations from Dame Judith. These were accepted by government. In December 2018, Building a Safer Future implementation plan was published. The implementation plan was in response to the recommendations. And in June 2019, government published the Building a Safer Future consultation, which detailed proposals to achieve a long-term reform of the building safety system. In August that year, the Competence Steering Group, which was set up jointly by the Ministry of Housing, Communities, Local Government, Build UK, the Construction Industry Council, Construction Products Association, and National Fire Chiefs Council, invited comments on its interim report Raising the Bar. This set out measures to improve competence in design, construction, and fire sectors. The consultation contained proposals for the overarching system for overseeing competence requirements for buildings. Next year, in April 2020, the government published its response to the Building a Safer Future consultation. It set out how it intends to deliver reforms to the building safety regulatory system. And then in October 2020, Setting the Bar was the second and final report of the Competence Steering Group. Then we move forward to 5th of July 2021, when the Building Safety Bill was introduced to the House of Commons. Government also published an industry fact sheet to provide information about key provisions in the bill, a transition plan outlining the timeline or indicative timeline for commencing these provisions, and indicative draft secondary legislation. And then in 28th of April 2022, the Building Safety Bill received Royal Assent, becoming legislation known as the Building Safety Act. April 2023, this year, we will see the launch of the Building Safety Regulator, and in October 2023, full implementation of the Building Safety Act. And then finally, in April 2024, the operational standard rules enforceable, ensuring consistent regulatory approach for building control across the whole built environment.
Very interesting. Richard, could you please talk us through the principles of the Act?
Yeah, absolutely. John's already identified there's been a huge amount of work already done, but the Act and all of the elements around the Act are nothing short of transformational change for the industry, and quite rightly so following the disaster of Grenfell. And we've seen previously where we've had major disasters, such as in football, there is transformation need. And when that takes place, we get a much better outcome. So government has been working to ensure that we can do that. And at its heart is putting safety and residents at the heart of this new system. So we've got to move away from lowest cost to thinking primarily about the safety of people in buildings that are covered by the new regulations, the new Act. So what will that do in terms of other principles? It's assuring the safety in the high risk buildings, not just during their occupation, but during construction as well. So the whole life cycle of those buildings. John already mentioned competence, driving competence through the industry to ensure that all those responsible for overseeing, managing and delivering works in buildings is raised to ensure they are capable of doing the job properly. We want to drive new standards and improving standards of delivery and its associated accountability, as well as the guidance on how to achieve that. So what does it mean? It means we're going to be getting new gateways through which all these buildings must pass, and also changes in how we deliver the regulation of that. Who is the regulator, not just for the high-risk residential buildings, but regulation throughout the country on all buildings.
Thank you. Staying with you for a second, Richard. We know the life cycle of the building. Sorry, we know the life cycle of the building will change over time. So, in a practical sense, what information needs to be kept as part of the 3 gateways?
Right. This is the infamous golden thread.
Yes.
So Dame Judith in her report talked about the golden thread of information. That one of the issues that she found when she was writing a report was the inability to track information through the life cycle of the building, to know what information was relevant and at what time. And she suggested this idea of the golden thread. Also sitting alongside that is going to be a new regulator, not just the regulator for building control, but a new products regulator as well. So a real focus on construction products and systems, how they operate, how they're maintained. Now, actually, a panel that I think John was involved in within BRAC was looking at the golden thread and the principles by which we could deliver a golden thread. And those principles are that the golden thread should be accurate and trusted. It would allow residents, therefore, to feel safe in their homes, driving that cultural change, a single source of truth, secure and accountable, understandable and consistent, simple to access, so accessibility of that information, not just during the construction phase, but crucially for residents to be able to access that information as well. That information has to be durable. We know that when we think of digital, that we sometimes can't read files that we might have opened 12 years ago, for example. This has to be relevant for the whole life cycle of the building, and it's got to be relevant and proportionate. We're not overburdening. So BRAC tasked a group of people to come up with a definition and also to come up with what those data requirements might be, chaired by a chap called Hal Davies from CIBSE, who's a long-standing expert in some of these areas. And one of the things I love from this is we've got a definition of the golden thread. I like definitions. It makes it really clear what we're aiming for. And their definition is that the golden thread is both the information that allows you to understand the building and the steps needed to keep both the building and people safe now and in the future. And the great news is that we actually have an awful lot of the standards, the data rules in place for us to be able to do that. So The aims are that the golden thread, this is the aims of the golden thread has to be digital tools and systems. We don't want thousands and thousands of paper documents locked away in a cupboard somewhere where nobody can see them, nobody can maintain them. So it has to be stored and used effectively. It will support the duty holders, and I know we're going to talk about duty holders as part of this webinar, but the duty holders have some really difficult challenges to meet to do their job properly. So it will support that. It will incorporate all the information needed for the life cycle management of the building, its construction and use. It will make it really easy to access information. Once again, construction users and building users, and it will put place a higher information standard. It's going to drive improvements in the way we manage information in the industry. So how are we going to do it? Well, we already have the primary legislation, that's the Building Safety Act. For the golden thread, we have a new piece of secondary legislation on the way that will define what the information requirements are, and there'll also be guidance supporting that. But if you want to know about good information management now, I would point everybody to the UK BIM framework. It's freely accessible information. Go and search for NIMA, N-I-M-A. It used to be the UK BIM Alliance. There is voluminous information available that will help you understand how to manage information, how to procure information, and also how to provide the information needed. But let's not underestimate, for everybody involved, this is going to be a huge cultural change, the way we design, manage and deliver and operate buildings.
Jon, I know Richard briefly touched on duty holders. Can you give us a little bit more understanding about the role of duty holders?
Sure. There are three main roles. These are principal designer, principal contractor and client. The aim being to change the culture highlighted in the Grenfell Independent Report and the public inquiry, creating a great emphasis for buildings to be built to the design. If you take the client, everything starts there. The client has a critical role by setting the tone, expectations for building work and projects. The client is aimed at encouraging a collaborative approach to procurement. The client appoints the principal designer and the principal contractor, and the client also ensures that suitable arrangements for planning, managing and monitoring a project. Client is undertaking allocation of sufficient time, resources to put in place management arrangements, and also ensures that arrangements are maintained and reviewed throughout the project. The client then provides building information as soon as practical to every designer and contractor on the project. The principal contractor role, the overall responsibility is to comply with the building regulations, plan, manage and monitor building work during construction phase. The principal contractor coordinates matters relating to building work and ensuring the work is in compliance with all relevant regulations. Where the principal designer has provided comment in relation to compliance, the contractor ensures they're taken into consideration, and the principal contractor is responsible for effective record keeping of design changes to a high level of detail to be incorporated into the golden thread we just heard about. For the principal designer, their role pretty much mirrors the principal contractor to plan, manage, monitor and coordinate building regulations compliance. The building safety regime, like CDM, takes this very broad view that anyone designing, planning or in detailed pre-construction or on-site risk management of work will probably be a designer. The principal designer should be a designer with influence over design decisions. The principal designer coordination does not mean being an expert in every design specialism, but the designer PD should understand building regulations and should help contractors demonstrate that elements are built properly. The benefits of all this is to ensure better coordination and communication between the different teams and the duty holder roles, improved integration of safety and design, more understanding and awareness of design risk, improved project information, again, as mentioned earlier with the golden thread, and ensure that the right culture and therefore behaviours are applied throughout the building life cycle.
So, is there anything you would like to add to what Jon said?
Yeah, I think in there Jon mentioned collaboration, and I think once again we need to be looking at how we actually get all of the duty holders to work together. I think one of the issues that we've been trying to resolve with the duty holders is that the industry has been very adversarial, and that adversarial nature, that drive for low cost, has been problematic and is something that we have to change. So I would really like to see, as part of that emphasis on collaboration, that we really do get that. There is really good information sharing, and if we do that effectively, the outcomes for the building users and for the construction clients themselves will be better, because we'll actually de-risk the whole process and find that we get other additional benefits to this core drive for building safety.
So, Richard, how do you think we can promote best practice within the new Building Safety Act and sort of prevent misinterpretation of product information?
Two things in that question. One is driving that cultural change. The other is the product information. So let's start with the product information, because that's where, as I mentioned a little bit earlier, we've got a new regulator. So under the Office of Product Safety and Standards, we've got a new construction products regulator. They will look at products which have to be safe. And as part of the ongoing process to publish information for the industry, we will get a list of products that are going to be covered by the new regulator. Those products will have to be able to demonstrate safety. And I think that is going to be a huge, huge step forward. I think we could probably take that further in the future and look at how we do that. But for the moment, that first list is going to be fundamental for the industry. If you are a manufacturer in one of those areas, you will have some new rules applying to you. In terms of driving cultural change, that's really hard. We were talking about this a little bit earlier. This isn't a change which is going to take place, however much we might want. It's not a change that's going to take place overnight. And we know that there is a need to do that, but it will take time. Cultural change always takes time. And I think we can learn really good lessons from how we delivered these sorts of changes in the past. If we look at the CDM regulations and the implementation of the CDM regulations and whether that worked properly first time round, certainly we started to see some improvement in site safety, but we also created additional bureaucracy. So we might also learn from the implementation of the UK BIM initiative. And with that, it was very much about how we promote the aims. So what are we trying to do? And we've done that with building safety. We then also provided lots of guidance and support. The UK government paid for standards, so to make them freely available, so the industry didn't have barriers to change. And it set clear targets for when things would happen, how things would happen. So that gave really clear steer to the industry. This is what we want you to do, and this is how you go about doing it. At the end of that, of course, there's a big stick. And with BIM, it was that you wouldn't be able to work on projects. The big stick here is legislative. These will lead to prosecutions, I think, in the future if people do not do what they're supposed to do as part of the Act. So we've got all the good things, but we've got that stick at the end of it as well.
Indeed. Jon, the regulator has been operating in shadow form for some time now, and such were the huge issues surrounding industry competence highlighted by Dame Judith Hackitt and responded to by the government, that there has been an interim industry competence committee, which you chair, since July 2021. So I'm wondering, what are the key actions that you've taken as part of the IICC, and what advice would you give to industry in preparation for the new building safety regime?
Thank you. Well, as the IICC, we've been engaging with industry for a couple of years now, promoting some key messages surrounding competence. These are such as competence goes beyond skills, training, experience, and knowledge, and includes the behaviours that Richard just spoke about, the importance of organisational capability and how it can impact the individuals within the different roles, which goes again to the behaviour element. The fact that compliance now relates directly to competence. And for the BSR, as the Building Safety Regulator, and the Act itself, competence requirements go beyond high-risk buildings and is throughout the entire built environment. The principal activity we've been doing has been to pave the way for the new statutory industry competence committee, so that when it stands up around September, October, it can hit the ground running. And we've therefore developed a recommended 3-year strategy for the ICC for the regulator to review and hopefully accept. The committee, meanwhile, is continuing to work on baselining industry competence and the capacity and capability moving forward, so that ICC can establish key performance indicators to understand where different areas of industry are at any point and how far they are off where they need to be, as well as therefore you can actually understand when you need to actually get involved and help industry move forward. And finally, we've been developing guidance for the ICC to use with industry, most notably of which is the Culture of Competence Initiative. This looks at culture throughout an organisation at different roles and how they interrelate. As regards industry priorities, I'd say it's to assess the people it appoints or employs and put policies in place to allocate only those people who have proven competence to undertake the work they're being asked to do so. I think following on from that, I think industry will rapidly need to look at continuous improvement of competence management, investment in training and development, and building the technical capability to ensure compliance.
Staying with you, John, in the case where something goes wrong, how does the Act address accountability and ownership?
This is an area of, as you imagine, a lot of debate. I think when you go to one of the government's aims in passing the Act was to expand the avenues available to stakeholders to bring those parties responsible for construction defects to account, particularly in the residential sphere. There are 3 new legal avenues of claim which have been introduced: a direct right of action against manufacturers and suppliers of construction products, a general right of action for breach of the building regulations, and the expansion of existing rights under the Defective Premises Act of 1972. There have been considerable amendments to limitation periods, with some retrospective in nature. Under the DPA, work in relation to new buildings already completed now has a 30-year retrospective limitation, with 15 years for future work. Damage caused by breach of the building regulations has now moved from 6 to 15 years as prospective. And as regards sections, I think 147 to 151 of the Act, dwellings rendered unfit for habitation as a result of a construction product being inherently defective, missold, or where there's been a breach of the existing product regulations, this has 15 years prospective limitation, but as regards cladding, as we've seen a lot in the market, also 30 years retrospective. Aside from the limitation periods, the Act has amended the DPA so that work to an existing dwelling is now covered, as formerly DPA only covered construction of new dwellings. For example, work to refurbish an existing block of flats done by a contractor. As a result of that work, one or more of the flats are no longer fit for habitation. This would constitute a breach of the duty under the new Section 2A of the Defence Premises Act 1972, and leaseholders of the affected flats would be able to bring a claim through the civil courts against the contractor for the cost of rectifying the work. Also, the Act contains highly significant provisions which allow liability for construction work to be extended to associated entities, such as parent or sibling companies. This is under a court action called a building liability order and has been focused upon with the Grenfell inquiry. So in summary, I'd say the Act, its application by the BSR and the National Construction Products Regulator, as well as the court-related powers, has completely changed the liability landscape for construction work in the UK. The new rights of action in relation to construction products works and extended rights under the DPA apply solely to residential construction products, but Section 38 of the Building Act 1984 and the ability to apply for these building liability orders will apply more generally, both residential and commercial. I think it's fair to say the impact of this will be considerable on the market, as well as secondary markets such as insurance. However, I would reiterate that the overall aim of this is that those responsible for serious construction failings can be held to account by those who suffer loss or harm as a result.
Is there anything you would like to add?
It's interesting because we can see the reasons why this is being done and the outcry we have seen across both the industry and the wider public. I know there are others in the industry, though, who have some concerns about this extended liability, and in particular the retrospective application of some of these rules beyond periods where insurance might cover. So we've already seen on the design side the huge increases in professional indemnity insurance, and I know there are some worries that there may be some of these risks which are not insurable. John's already mentioned the secondary market of insurance, so I think within the industry we're going to have to keep a really close eye on how this works and what claims come through, so we start to understand the impact on the industry, because what we don't want is for the industry to be unable to design and build. That would also be a failure. But quite rightly, we have to put building safety at the heart of what we do. So somewhere within there, we just got to figure out how all of this fits together.
I know, Richard, you briefly touched upon cultural changes a few minutes ago. So what behavioral and cultural changes need to happen for the implementation of the Building Safety Act?
Well, as I've already mentioned, the cultural stuff is huge and will take time. There's this idea of this generational shift that we were talking about previously, but it does come back to defining behavior and making sure that everybody in an organization working understands what the objectives are of the project, the rules in which they have to operate, so whether that be regulatory, but also different organizations set different values for themselves, and they will identify how they want to be able to operate. It isn't just sometimes about hitting the minimum. It's not about hitting the lowest we can go. It's about saying, what do we as organizations want to achieve? I go back to BIM again, and organizations who just want to do the minimum in terms of information management, and those that believe by doing a better job they can build their businesses more effectively, because actually they want to go beyond the norm. They want to be exemplars in their sectors. And I think there's a really interesting argument, a really strong case for organizations saying, actually, we're going to understand what the minimum is, but we want to be better. We want to be seen to be leaders in our areas. And I'd really like to find ways of helping organizations who want to do that, because I think that's great for everybody. And then we can show the rest of the industry not just what the baseline looks like, but what great looks like, and how we can really push those boundaries.
John, any thoughts on what Richard just said?
Yeah, obviously I'd agree with him, as in it's difficult, isn't it? Because the construction industry has been based off cost so much, particularly in how it delivers on site. Looking at it from the lens of the competence element, as in there's been a lot of work with things like ESI, as in 8670, the flex and all that, about competence, particularly at an individual level, and it's got 8671, 2 and 3 for the different junior holder roles. But the culture of an organization and its behavior can render someone who is deemed competent in such a lens incompetent by, say, giving them half the time they need to do a job or giving them poor tools. And so getting this properly embedded, but then finding ways to measure it, which is very tricky, is going to be massively changing for our sector. And then getting that understood in the procurement process, as in actually having a scoring system that puts some weight behind this. It does go against what we've seen to date.
Yeah, and I think, sorry, Shamilia, just in my previous role, I used to talk about product selection, system selection, and the 3 C's of doing that. And the first one is compliance. Whatever product or system you choose in a building must meet the requirements of that product, its functional performance requirements. Then we have cost, and then we have carbon as an emerging theme. But you can actually have the same feel on people. You know, compliance, you have to be able, when you're pricing a job, whether you're a contractor or a designer, you have to ensure that you're putting enough in there so you can do the job properly. And that culture of cost cutting leads to failure. So I think we really do have to find ways of ensuring we move away from cost to competence.
Yeah, I was just going to say, actually, because it is the cost thing, but it's also the delivery timelines, isn't it, that actually have really impacted the industry. So substitution on site to get something done on time leads to, let's just say, a number of gaps in overall delivery. And anyone that's been involved in large-scale construction, we've all done it at some point in the past, and that's the worry, isn't it? It's so easily done. We have to hit this barrier. We have to deliver at that point. There's going to be inside occupation. We've got to get this done. And so, where do we go?
Yeah, interesting. Just so the cultural change there. As part of work with WG12, we looked at, and the Construction Products Association, MBS looked at finding out about substitution and product substitution, and it was something like in a third of cases. If you go and search for CPA and MBS, you'll find this report. It's something like a third of products were substituted, and the critical thing for me was 10% of those were done without the authority of the original designer. And that's part of the cultural change, because sometimes substitution can deliver a better product or system. So it's not all bad, but it has to be done understanding what the crucial design requirements are, so we still meet the original performance of the building. And I think that's part of the cultural change we've got to get to.
John, I know you've been, we've just had recently the Building Safety Regulator Conference. Would you be able to share some of the highlights from that conference?
Sure. Yeah, it was Wednesday last week. I think overall it was great to see so many people in a room together. I think it was about 1,000 people. I think it was massively oversubscribed, so you could have probably filled the room about 10 times over. But it was collectively looking at changing landscape and how we collate information that's occurred since the Grenfell tragedy, as well as setting the expectations from the regulator and how industry will respond. I think it's fair to say a lot of information was given. There's still stuff that needs to be decided, and I think BSR was particularly clear on what is done and what is still being worked on. There was discussion on the fact that 2 of the statutory committees have already stood up, which is the Building Advisory Committee and Residents Panel, stood up in December last year, and the 3rd, the Industry Competence Committee, will be done so by October. BSR wanted to ensure, I think it was fair, that it was broadly understood that this new building safety regime is happening, and I think it's fair to say the time for debate is over. Whilst there is some information still required, direction of travel is assured. Oversight on building control was focused upon, both for public and private sector, laying out requirements, particularly with the opening of the new building control register in October this year. BSR made it clear that it's going to be active. It comes out of the HSE, which is regulated by nature. It will therefore regulate as required. So I think some warning shots were fired that those who transgress will face greater consequences and focus. Duty holders that we covered earlier was a pretty big focus, as well as the changes beyond what is existing CDM from 2015. Collaboration, key theme, getting industry together. There was a panel on competence in the middle of the day, talking about how we relate from the regulator down through committees such as the ICC through into industry, both in development and in occupation activity. And finally, I think it was showing the support across the spectrum of government, with Lee Rowley MP was there, DLUT, OPSS, and senior figures within the HSE talking of the key core values and what they're going to focus on in their position as the BSR, as well as this is how you need to get involved, this is how you engage, this is how you stay updated, because the regulator and I think the process for change from now will move rapidly.
Richard, what is the BBA's role going forward?
Well, clearly out of all of this, we've got thousands and thousands of clients. We've got thousands and thousands of designers, thousands and thousands of contractors, thousands and thousands of subcontractors, and thousands of products. Somewhere in there, how do we get clarity as to what is good? BBA has been delivering certification now for over 50 years and has demonstrated its expertise, its technical capability, and for organizations to be able to trust the information that the BBA provides. In this new regulatory role, people will be able to point to BBA certificates and their ilk to say, this is how we are determining that we have done the right job in making sure the products and systems that we have in buildings and in other projects are fit for purpose, can do the job they are supposed to do. The role of BBA will expand as part of this, and that there will be many more products that need that certification. BBA will also have to provide more information, I think, as part of this, to make that information transparent and available, all the principles that we've heard a little bit earlier. So I think BBA's role and the information it provides will be more expansive. I think it will become more of that trusted partner, because over time, as products are developed and then amended, that BBA has to be involved and to be able to show the information from those amendments to products, because even minor changes to products can have an impact on their durability, on their fitness for purpose. So we're going to see a lot more of that coming. Of course, we only know the real detail when we see the impact of this secondary legislation and the guidance that comes out from that. But where we're moving as an industry is into a much more regulated environment, quite rightly so, an environment that will require people to do the job properly, to be competent in all of the different roles that they assume, and as a result, deliver a safer future for not just the construction works, but for the residents and for construction clients as well. And I think that can only be a good thing. So I think we'll see BBA and its output being used in very many more areas in the construction industry.
Thank you for that. I will go on to that's the end of my questions, by the way. So I will go on to some of the questions that have come through. One of the first questions is from Alan. He says, he asks, where do product suppliers fit in with this new process?
Well, fundamentally, if we go back to Dame Judith's original report post Grenfell, 2 chapters out of that report, all about products and systems. It's fundamental. So product suppliers providing the right information that the industry needs, but providing information that is unambiguous, that is very, very honest in the content, that allows designers to understand the performance of those products is fundamental. I would point everybody to the CCPI and the work with CCPI, which is part of the Construction Products Association, and the work they've done looking at how you describe your product. They've just published a whole range of words and phrases that you should not use in your marketing material. So go and have a look at that and why you shouldn't use them. So it gives really great guidance, and also words that you might use instead. Or if you are going to use some of these phrases, make sure that you have evidence, so proof of what that means, how you define what that phrase means with your products and systems. But right at the heart of this are the construction product manufacturers, because ultimately it's your stuff that's going to end up in these buildings, and that's what's got to be right for the building.
And then he has a follow-up question asking, will there be different rules for suppliers of building safety products and general building products?
There will be further rules for those that are included on the register, on the product register. Absolutely. Now, do we know what those rules are? No, not yet. I think we can have a pretty good guess what they're going to be, but we don't know the rules until we get the secondary legislation and the guidance that will come from that secondary legislation, which will show what these products are. John, I don't know if you've got any insider view on that one.
No, nothing more than what you said. Obviously, this is a year of considerable second SIs being done, and I think one of the things that's been used, a phrase a lot, is proportionality, and this is being applied in several spheres, because it's with products, it's where you use them. As in, a product on itself, it then depends on the environment that it will be used in. So what type of building, so the relationship comes between a product and the environment, but you've also got the relationship between the product and people, which I know is something that BBA is looking at as well, because it's what skills do you need to actually interact with this product, what other products can sit with it in a product set, and all this is trying to be taken into ways of not just legislation, but also guidance for industry to work together. Because I think this is a huge change that has happened, is in you can't sit isolated in construction anymore and say, I just do this, that's my bit, and off I go. There is a responsibility on product suppliers to actually work with others and try and make it clear, because in the end we've got to go back to the clients and the key stakeholders and say, look, this is how it will work. They've got to be able to understand it, particularly if they're going to be liable for selecting it.
Absolutely, and that the point you made there about it comes back to substitution again. It's not just substitution of a product. If you change something in a system, it can have really quite a big effect on the performance of that system. So you've got to make sure when you're making those changes, you know what all the related impacts will be, and that means working as a team. It really, and I love that. I go back to the Latham report and building the team. It is about doing this together and not doing it in isolation, as you mentioned.
Yeah, a system will always fail on its weakest point.
Yes.
Next question is from Paul. He says the building regulations for fire when it comes to roofing are very ambiguous. Is there any function within the regulators or otherwise to simply present them with a product or product range and for them to tell you what the requirements are? This is especially relevant for ancillary roofing products such as roof vents, for which there is no information within the building regulation. Anyone who would like to answer that?
I've got to say, I'm not sure how to answer that. I think the initial focus is obviously about fire and structure, and whether that will get down to the detail of things like vents, I think probably, I would say, unlikely in the first instance, unless the regulator can demonstrate that that has an impact. So I'm not sure there's an answer to that question just at the minute.
Yeah, I think it's probably fair to say not yet. As in, the roofing industry is a funny one, isn't it? Because you've got about 13 or 15 active trade associations that get involved in, particularly around the products and the relationship between them. I've seen quite a lot of collaborative working in there, in that industry, but yes, the relationship between what you do on a roof and the products you use probably needs greater definition, I think it's fair to say, because in the end, the aim of all of this is not to catch people out, it's to keep them informed. But as you can imagine, there is so much information that can be put out there, and there's so much differences with the variety of products that actually some of the stuff that Richard spoke about earlier coming out of WG12 is utterly key. And the relationship between, working group 12, which is products, its relationship with working group 2, which is installers, and how those two interact to make sure that the overall what is produced is safe.
Answering the question in simple terms, it may be ambiguous at the moment, and it's likely to stay ambiguous for a while, whilst the focus of the new regulator is on those core areas, I think, is where I would say. But that, who knows? But my guess would be that won't be an element of focus just at the moment.
There's a question by Steve. He says, when is the list of when is the list of safety critical construction products expected to be published?
Now, it should be around now. I know that was a question on information provision came out at the conference last week. Was that one included in that list, John, or I'm guessing not.
I wasn't in the products ones. I was in the competence one. I'm sorry, Richard.
So the answer is that if we look at the original published timeline when the bill came out, 6 months before the application of the bill is when all of the secondary legislation was supposed to be out. Given the volume of secondary legislation that is still to emerge and go through all the checks and balances, I would be surprised if it comes out in April, personally, but we do need that sooner rather than later. I think it's the same for the list of those products. It's the same for the golden thread and the detail of that information. We're all waiting for the details so that the industry can prepare. And I think that could be a criticism of government, but there's so much changing at the moment. They've got an awful lot to get into the industry.
The next question is from Phil. He says, duty holders are those commissioning work or those undertaking work. Therefore, manufacturers who offer design-based solutions, do they become a duty holder as well?
I'm going to say yes, because actually we had this discussion before, John and I, about who is a designer. If you are introducing an element of design into your work, then I think you will be classed as a designer.
Yeah, yes, you could be, and I think this is one of the key points that's being made is in the limitations on the duty holder regulations, particularly because what we're doing in HRBs is being flowed through the rest of construction, and so it's setting precedents. Now, I know, as we said earlier, we talk about proportionality, but the simple fact is those that put something together against which people then produce work will fall under the designer category, and I think one of the things that we're obviously wary of, and maybe more in the domestic market, is locking down the market through fear of actually giving information. But this is what we're trying to do. A lot of the outputs, we've mentioned working groups several times here. There were 12 working groups under the competence steering group, all of which were producing things that help. So I think it's a lot of guidance to come, and I think doing stuff like what the BBA is doing here and giving out information and to keep giving it out creates a focal point of knowledge for people. So I keep firing in the questions, and I'm sure BBA will come out with what it knows as and when it happens.
Yeah, I think the RIBA, if memory serves, the RIBA did a survey of some of its members and found something like half were still really unsure as to how the regulations were going to apply to them, and that the detail of this is the bit that's missing. And as we've already said, this will take time to change. I don't think anybody's expecting the industry will change immediately overnight. But I think we all have to be heading in that direction, making constant steps forward so we are doing the job we're supposed to do.
There's a question by Jacqueline. She asks, will it still be permissible to have product test evidence with sentences like not disclosed by client? How can sentences like this provide clarity concerning evidence or constituents of the product, which could then allow for substitution?
Right. This is the difference between the recipe and the performance. So in some products, you may want to know what its constituent parts are, because there may be problems with some of those materials and the relationship with other materials in the system. Fundamentally, you can get around that by defining how a product actually performs in different circumstances. Once again, this is where we drop back to test criteria in standards, and we also look at the developing work around product information and product data sheets. So if as a designer you then find that the manufacturer is not providing the information you want, you may then have to decide whether that product is suitable for inclusion in a building project because you don't know enough about it.
The next question is by Jason. He asks, will the compliance with the Building Safety Act force suppliers to become more data-driven and drive them to leverage AI capabilities in terms of chain of custody?
Right, we introduced two things there. One is information and one is AI. AI works by working across huge volumes of information to be able to find trends, patterns, etc. So you could argue that actually, in many ways, as manufacturers provide more information that can be analysed, the role of product selection becomes easier because you'll be able to see things that work more effectively together. But should manufacturers be better at information provision? Absolutely. I think manufacturers will also need to start looking at their production processes and how they document their production processes as well. And of course, that's something that BBA can help with, looking at the manufacturer plans, so the delivery plans. And there's a huge amount that needs to be done across the sector to improve all of that. But once again, if you really want to get your product selected, make it easy for people making the decisions to choose your product. Give them the information they want at the right time in the right format is the easy answer.
Yeah, I think it's across the piece there, hasn't it? Because you've got the National Construction Products Regulator, you've got the Building Safety Regulator, both of which are evidence-based regulators. So that's the critical factor, is the more available the information is, the better enhanced industry will be. So I think there's huge drives, not just the golden thread itself, but across construction, from the tower blocks down to small domestic property, who've been very good at holding stuff back. And I think those days are gone. And I think it's been quite clear that actually you're more likely to put yourself into a position of conflict by not giving information than actually giving information that shows limitations on your products. So yeah, it's hugely data driven. And I think it's fair to say though, Richard, I think a lot of the systems that are required aren't quite there yet. So it's, they're in development. There's a lot of projects out there trying to piece things together. I'm sure BVA and yourselves are very well in amongst this. But it's huge change.
And you're right, there's been a lot of test projects running to see how some of these systems can work. L&Q, one of the big housing providers I know, is doing an awful lot of work, along with lots of the other really big housing associations in London. So many of the members of those associations on lots of different committees helping to deliver some of this guidance and information requirements. So, this isn't from a standing start. There's an awful lot being done, and hopefully guidance from some of those projects will start emerging as we see the detailed requirements coming over the next 6 months.
Yeah, I think the real trick in this is the comms piece, though. It's one thing to set something up, as in, what's the construction industry, about 1 million companies, 3.2 million people, trying to make sure that this is understood all the way through, from the largest tier ones down to the SMEs, is a neat trick, and trying to make sure that the availability of information is reasonable. We can't expect, the small SMEs to have big departments based around operational activity. So it has to come in a form that can be used, which goes right back to the heart of the golden thread, which is to make it usable. Yeah.
And the good news for us all is most people now who are working on sites will have a smartphone, and making sure that people are able to see through apps to be able to see that information. But it's not just those people in the industry, remember, to make it accessible, putting people, the building building users, the tenants, at the heart of this, means it's got to be accessible to them. So if it's accessible to a tenant, it's got to be accessible to that one man in his van who's coming to fix something.
On the note of SMEs, there's a question on the impact on small construction businesses. Virginia asks, what is the impact for a small construction business focused on agricultural and industrial buildings of the new Building Safety Act?
Do you want to do that one, John? I think that's the scope of the regulator, I think, isn't it?
well, the scope of the regulator isn't just residences, as in some of the act changes are for commercial too. So it does have an impact. Yeah, the exact scope. I couldn't really tell you. Actually, it's not an area of considerable focus. Most of the area I've been looking at is the residential aspect, obviously in the Grenfell response. But if you look at the changes, and maybe we can put out some of the changes around the Act after this webinar, of the different areas it impacts, you'll see that it's in there, particularly with the changes to the law.
Yeah, I think the only real impact there is choice of who's going to do the regulation assessment. It's now going to come, you won't have your own choice, your own ability to decide who's going to do that work for you. But at the moment, I think given the scope of what you mentioned in the question, I don't think much of this will apply at the moment.
Yeah, but it will naturally be drawn in, won't it, with the changes in the Act?
Yeah, over time, yeah.
I'll try to squeeze one last question in. There are lots more, but one last question is about building merchants, builders merchants. What about builders merchants that supply construction products from various suppliers? Will there be additional tasks for them?
Yes, in a way, because the builders merchants will also be part of that information handling. So where does the product come from? Where is it sourced? What are the performance requirements of that, or the performance characteristics of those products as well? That information will have to be available to the person as part of this supply chain. So yes, I think that data management, but actually lots of the merchants are really good at this already. So the compare and contrast stuff that they can do. So what product is like another product? But yes, they will have to provide that information, because it's part of the supply chain.
Yeah, I think it's fair to say that the builders merchants in the form of the Builders Merchants Federation are quite well plugged into the Construction Leadership Council, and so issues such as this are being taken into that. And originally it was, when you think when CLC was big, it was talking about COVID response and availability of products, but it's moved on there to working on building safety, to working on the future of digital information. So how we do it is going to be interesting. I remember days of old when part of the gas safe register, when they said, oh, can you only sell a boiler to someone that holds a gas safe registered card? And that didn't exactly take through the market. But I think the supply of information and that builders merchants are obviously a key point, particularly when it comes to the substitution of products.
And let's not forget, we bring something like £16 billion worth of products are imported into the UK every year. So, and a lot of that will go through third parties and merchants.
Yeah. But obviously, if you want to get into UKCA marking, Richard, you can take that one.
One last question. I think I just have a couple of more minutes. If a merchant says a product is suitable for a customer's requirements, i.e. specifying that product, do they become a designer?
Well, they are making a design decision, aren't they?
Yeah, I think, right, I'm not a lawyer.
No.
But if you say something is suitable, that is a design decision to my mind. So yes.
EJ, I think that sort of summarizes and answers your question. Okay. We have lots of other questions, but which unfortunately due to time restrictions I'm unable to ask all of them. But we'll get back to all these people who asked questions. I will float them to the panelists after the webinar, and we'll get back to you with the answers to all those questions. Thank you, gentlemen, for joining me today for this webinar, and thank you everyone for joining us today. Again, this session was recorded, so the webinar will be made available in due course, so please keep an eye out for the link. If you have any additional questions, please feel free to send a message or email to clientservices@bbasert.co.uk. And thank you for joining us, and have a good rest of the day. Thank you. Thank you, John. Thank you. Thank you. See you
Thank
then.
you.
Bye.